Okay, so today we're diving into something that honestly might sound a little dry at first, but trust me, it gets interesting really fast. We're talking about partition actions in California.
Partition actions.
Yeah. So picture this, right? You and your siblings inherit your childhood home. But instead of like warm memories and all that, you're just stuck in this family feud because nobody can agree on what to do with the house.
Oh, I've seen that happen. It's a classic scenario, way more common than people think. And that's actually where these partition actions come in. They're like, I don't know, a secret weapon in California real estate law.
Okay, a secret weapon. I like how that sounds. That's way more exciting than just saying partition actions. But seriously, what is a partition action?
Well, to put it simply, it's a legal process that lets any co-owner of a property force a sale or a division of that property, even if the other owners are totally against it.
Even if they absolutely don't want to sell.
Even then, yeah. And you're right, California law is particularly strong in this area.
From what I've seen in all these legal articles and cases you sent me, it seems like a big part of that is this whole principle of every owner having an absolute right to sell their share.
Exactly. That's the core of it all.
Yeah.
Of course, you have exceptions, especially with community property and spouses, that gets into family law territory.
Right, of course.
But in most situations, yeah, that right to partition, to basically force a sale or division, it exists, even if the property has, like, mortgages, easements, all that.
What if the property is being rented out?
Still applies. There's this case, Gardner v. Cord, really interesting. It basically solidified that the right to sell can't be blocked by existing leases.
So even if someone's renting the place, you can still push for a sale.
Precisely. The court basically said you can't hold a co-owner hostage with a lease.
Wow, that's a pretty strong precedent to set. So let me get this straight. If someone, say, inherits a property with a sibling or maybe a business deal goes sour, they're not stuck just because the other owner's being difficult?
Not at all. And that's exactly why understanding these partition actions, they're important for anyone who's thinking about joint ownership in California.
So it's like having a legal trump card.
I'd say it's more like a strong negotiating tool, a way to get everyone on the same page. But there are different types of partition actions, each with its own pros and cons, you know?
Okay, well, let's break those down then. Because if I'm going to wave this legal weapon around, I want to know exactly what I'm getting myself into, right?
Right, of course. So let's start with the most common type, partition by sale.
Okay, partition by sale.
This is where the court basically steps in, forces the property to be sold, and then makes sure the money from the sale is split fairly between the owners.
So in our childhood home example, the house gets sold, and whatever it sells for, that gets divided between the siblings.
Exactly. And it's usually the cleanest option, especially when emotions are running high or nobody can agree on what to do.
Yeah, makes sense. Just cut the cord and divide the cash. But that can't be the only option, right? What if someone wants to keep the property?
You're in luck. There's another option called partition by appraisal.
Partition by appraisal, okay.
This is where one of the co-owners essentially buys out the other owners at a price that's determined by a professional appraiser.
So say one of the siblings really wants to stay in that childhood home. They could theoretically buy out their siblings' shares based on what the appraiser says it's worth.
Exactly. It can be a good route if, everyone's on decent terms and agrees on the appraiser. But it's definitely less common than the partition by sale.
I can see why. I mean, if everyone was that agreeable, they probably wouldn't need a lawyer in the first place. They could just work it out over dinner, right?
Exactly. Now, there's one more type of partition in kind, but it's like finding a unicorn. Super rare.
Okay, now you have to tell me what makes this unicorn partition so special.
Well, partition in kind is when the property itself is physically divided between the co-owners. So imagine taking that inherited house and literally splitting it into separate units, each with its own entrance, utilities, everything separate. Sounds simple in theory, but gets really complicated.
Yeah, I can imagine.
Especially with California's Subdivision Map Act, it really makes it difficult to divide developed land.
So trying to split a house 2, 3, 4 ways, that's like a legal and logistical nightmare.
Often, yes. It's usually only doable for large plots of undeveloped land, and even then, it's tricky.
So realistically, most people who are looking at partition actions, they're looking at a sale of some kind, either forced by the court or negotiated between the parties, right?
That's right. But before anyone jumps headfirst into this whole partition thing,
yeah,
they really need to understand the benefits and the drawbacks.
Right, because knowledge is power, right?
Yeah.
So what are the big pros and cons someone should know about before going down this road?
Absolutely. Let's start with the good stuff, the upsides. The biggest one is it gives you a clear legal path to resolve these ownership disputes, especially when communication is broken down.
And I imagine even just the threat of a partition action, that could be enough to get people talking again.
Oh, absolutely. It can be a powerful motivator. Another advantage is the potential to recoup costs. Like, let's say you've been putting money into the property, maintaining it, fixing it up. You might be able to get those expenses back during the partition.
And I saw in one of these legal articles that you might even be able to recover legal fees from a difficult co-owner.
That's right, which for some people, that's a pretty good incentive.
Okay, so a path to resolution, possible cost recovery, and maybe even getting some legal fees back. That doesn't sound too bad, but you said there were downsides.
There are, and they're important to keep in mind. Partition actions, they're powerful, but they're still legal proceedings, which means they can get expensive. You could easily be looking at over $15,000 in legal fees. Plus, they can drag on for months, sometimes even years.
I bet it's incredibly stressful too, especially if it's family or friends involved. It's not just a business deal gone wrong, it's personal.
Absolutely. And from a purely financial standpoint, remember that a forced sale, which is often what happens, it rarely gets you the same price as a voluntary sale on the open market. So you might actually end up losing money compared to just selling it the traditional way.
Okay, so it's a powerful tool, but not without its risks. You really got to weigh those options carefully.
Exactly.
We've talked about the what and the why of partition actions, but what about the how? What does this process actually look like in a California courtroom?
That's a great question, and that's where things start to get really interesting.
Well, don't leave me hanging. Walk me through it.
Well, it all starts with something called a complaint.
A complaint. So, I just call up the court and say, hey, I'm mad. My brother's being impossible.
Not quite. It's a formal legal document. You got to file it in the county where the property is. And it has to lay out all the details, like who the owners are, what percentage each person owns, what you're actually hoping to get out of this whole thing.
Okay, so we are talking paperwork, but I'm guessing I don't have to show up in court right away?
Not right away, no. Once that complaint's filed, it gets served to all the other co-owners, which basically just means they're officially on notice, you're serious about this, and that usually kicks off a period of, back and forth negotiation.
So this is where having a good lawyer really comes in handy.
Absolutely. A good lawyer can make all the difference. They can help you navigate those initial conversations, maybe explore some other solutions before things get too heated, like mediation, for example.
Right, mediation. I was going to ask about that. It seems like a much more, civilized way to handle things than a courtroom showdown.
Oh, for sure. It's way less adversarial. It's basically a structured negotiation with a neutral third party, the mediator.
Okay, so they're not there to pick sides or make decisions. They just kind of keep things moving.
Exactly. They help everyone communicate, explore options, hopefully reach a solution everyone can live with.
So it's like a chance to hash things out in a, less charged environment.
That's a good way to put it.
But what if mediation doesn't work? What if there are just some things you can't agree on?
Well, if mediation fails, or if there are major sticking points, that's when it goes in front of a judge.
Okay, so we end up in court. What happens then? Does the judge just bang the gavel and yell, "Salt"?
Not quite. It's not an auction. The judge will review the case, listen to arguments from both sides, and then, they make a decision based on California law and the specifics of your situation. Sometimes they might even appoint a referee.
A referee? Like for a basketball game?
No, not exactly. In this case, a referee is usually a neutral attorney or maybe a retired judge, someone appointed by the court to help manage the process.
So they're like the court-appointed adult in the room when things get messy?
Exactly. But even with a referee and a judge, there are still potential issues that can come up. One of the big ones is figuring out the fair market value of the property. It's not as simple as just checking Zillow and calling it a day.
Right, because there's so much emotion involved. Like if you've poured your heart and soul into a place, or if it has sentimental value, it's worth more to you, right?
Yeah, exactly.
Yeah.
And even with a professional appraiser, there can be disagreements, especially if one owner has made improvements, upgrades, things they think add value. Then there's the whole accounting side of things, which can get really messy.
Oh, I bet. Trying to untangle all that. Who paid what? Who owes who?
It could be a nightmare. And then you always have the chance of hidden title issues. Those can really throw a wrench in things.
Like what? Give me an example.
Like maybe there's a lien on the property that nobody knew about, or something unclear about the ownership percentages. Those are the kinds of things a good real estate attorney can help you uncover.
Okay, so we've covered the benefits, the downsides, the whole process. But it seems like ideally you'd want to avoid this whole partition thing altogether, right?
100%. Prevention is key.
So what can people do to avoid ending up in a partition war in the first place?
Honestly, it all comes down to communication and being crystal clear from the very beginning, especially if you're buying a property with someone.
You mean like, don't just rely on a handshake and a hope?
Exactly. Get everything in writing. Ownership percentages, rights and responsibilities, how you'll handle selling, expenses, maintenance, everything.
There's like a prenuptial agreement, but for property.
Exactly. That way there's way less room for misunderstanding or arguments down the line. And when it comes to inheriting property, encourage those tough conversations about estate planning early.
Because even with a will, things can still get messy, right?
Absolutely. And having open family discussions about expectations, potential disagreements, even worst-case scenarios, it can really help prevent those issues from blowing up later on.
So communication is key, even if it's a tough conversation to have.
Exactly. But even with the best laid plans, sometimes these situations are just unavoidable. And that's when having a skilled legal expert on your side is absolutely crucial.
Okay, so let's talk more about that. Our research shows that here in California, the right to partition is very strong, but the process itself, as we've seen, is complex. What should someone be looking for in an attorney if they find themselves facing a potential partition action? So we're talking about finding a legal expert, but this isn't like, just hiring a lawyer for a parking ticket. What kind of specific experience should someone look for when it comes to partition actions?
You want someone who really knows the ins and outs of California property law, especially when it comes to these partition actions. They need to understand the whole process, the local courts, any recent cases that might affect your situation. It's one thing to know the law, it's another to know how to use it,
So basically, don't just go with the first lawyer you find online.
Exactly. Look for someone who specializes in this stuff, someone who can show you they've handled these cases before and won. Ask around for referrals. Read reviews, maybe even talk to a few different lawyers before you choose one.
Yeah, because like you said, this whole thing can get expensive and stressful. You want to make sure you've got the right person on your side.
Absolutely. A good lawyer can make all the difference. They'll explain your options, anticipate any problems, and guide you towards the best possible outcome.
That's good advice for any legal issue, really. But before we wrap up, there's one more thing I wanted to touch on. You mentioned these unique defenses to partition actions, things like adverse possession.
Oh, right. Adverse possession. That's an interesting one.
Can you refresh my memory on that?
Basically, it's the idea that if someone's been living on a property, using it openly and continuously for a certain amount of time, they might actually be able to claim ownership, even if they're not on the deed.
Wait, really? So even if you think you have a slam dunk case for a partition, there could be these hidden things that change everything.
Exactly. You could have historical claims, boundary disputes, weird stuff with the chain of title, things that create loopholes or unexpected legal arguments.
Wow, so it really is like a real-life game of Monopoly, but with much higher stakes.
That's a great way to put it. And that's exactly why having that experienced attorney is so important. They can spot those potential problems, navigate those complexities, and make sure your interests are protected.
This whole conversation has been eye-opening, really. We went from a simple question of what happens when co-owners disagree to this whole web of legal stuff.
Property law, especially in California, it's rarely simple, that's for sure.
So as we wrap up this deep dive into partition actions, what's the key takeaway you want our listeners to remember?
I think the biggest takeaway is knowledge is power, plain and simple. The more you understand about joint ownership, the better prepared you'll be. You can navigate those relationships, protect yourself, and hopefully avoid those nasty legal battles in the first place.
And if those battles do happen, don't be afraid to get expert advice.
Exactly. A little legal guidance can go a long way.
Well, this has been incredibly insightful. Thanks so much for joining me on this deep dive.
It was my pleasure. Really enjoyed it.
And to everyone listening, we hope you found this deep dive helpful, maybe even a little entertaining. And remember, whether you're buying property with a friend, inheriting a family cabin, or even thinking about a timeshare, understanding your rights and options when it comes to joint ownership, that's essential. Until next time, happy exploring.
Call now 714-442-9741. Thank you.